Furthermore, my dear friends, as we are continuing with the new series, that is case studies, so let us let us first of all define what a case study is. So literally we can say that a case study is a detailed study of a specific subject such as a person, group, place, event, organization or phenomenon. Fine. Case studies are commonly used in social, educational, clinical and business research. Fine. But we focus more we focus more on the aspects, facts, issues, decisions taken, etc., etc., when the two parties, or we can say when two parties are opposing each other on some conflicts in the world of patents. Fine. So let us dig a little deeper by going into some specific cases. Fine? Okay. Wow. So, with this beautiful figure, let us proceed with the detailed one. Fine? So, friends, now it's turn for case study number 7, and the topic is Controller Manufacturing Industries Ltd versus Sergi Transformer Explosion. Okay, so let us proceed with the details on this case. Okay, let us proceed. So, friends, we will proceed with the facts. Okay, so, Controller Manufacturing Industries Ltd originally filed a suit for infringement in 2010 before the Thane District Court of Mumbai. Okay, but the filing of a counterclaim challenging the validity of the patent by Sergi necessitated the transfer of the case to the Bombay High Court under the proviso to section 104 of the Patents Act 1970. Okay, let me tell you this. First of all, what happened? Controller Manufacturing Industries Limited filed a suit for infringement in the year 2010. Where? Before the Thane District Court. Okay. But the filing of a counter claim challenging the validity of the patent. So, who will file the counter claim? The opposite party, that is the Sergi. Okay. So, this claim, and or we can say the case for infringement and the counter claim both necessitated the transfer of the case to the Bombay High Court. Okay. As we know, friends, that though Bombay has been the name has been changed to Mumbai for so long, but still some institutions are there, some premier institutions are there also, and whose name is still uttered as Bombay only. That's why Bombay High Court is one of them. Fine. So the case was filed before Bombay High Court under section 104 of the Patents Act 1970. Got it? Okay, next. Sergi had earlier filed both pre and post grant oppositions to the suit patent as well as a revocation application before the IPAB. Okay, though in the previous statement we have discussed the patent infringement case filed by someone, then the counter claim filed by the opposite party. Okay, but before all these things, the Sergi, that means the opposite party, it had earlier already filed the pre-grant opposition, and that means before granting of the patent. Okay, and the post-grant opposition also. Also, it had filed a revocation application before the IPAB, that is Intellectual Property Appellate Board. That means so many objections are there. Okay. Now, the suit patent covers a method of detecting and preventing transformer explosions through a device that combines a differential relay sensor, a Buchholz relay and a circuit breaker. Okay. So what is the patent about? This covers about a method of detection and prevention of transformer explosions. Okay, transformer explosions through a device. That means a device. That means we can say the method has been implemented through a device which combines a differential relationship, a Buchholz relay and a circuit breaker. Okay, so these are some of the facts of this particular case. As we have mentioned here, what is section 104? So let us go for the title, and the title for section 104 is jurisdiction. Okay, so let us proceed. What happens? Now, continuing with some more facts. Sergi claimed that its product, the Sergi 3000, was covered by its own patent, that is IN 189089, or we can say 089 patent. These are the names only, and did not infringe the claim of the suit patent. It also argued that all three components of the controller's patent were, or we can say all three components of the CTR's patent. This is the short form of controller manufacturing that we are studying about. Actually, CTR is a brief version of Controller Manufacturing Industries Limited. So we can just utter it like CTR. Okay. So it also argued that all three components of CTR's patent were anticipated by prior art, and therefore the patent itself was granted in error. That means all these arguments are from Sergi. Okay, so Sergi says that it has a product patent, that is the Sergi 3000. Okay, and its there is a patent number, or the patent's name is 089 patent, etc. And it says that it has its own patent, and for this reason it had not infringed the claim of the suit patent. Okay, that we are discussing about. It also argued that all the three components of CTR's patent were anticipated by prior art. Another objection. Okay, and therefore the patent itself was granted in error. That means Sergi says that granting a patent to the CTR is totally an erroneous act. Okay, because so it has so many objections for the CTR. Okay, now see. Now CTR argued that Sergi had ceased manufacturing products according to its 089 patent. CTR says that though Sergi had a patent named with 089 patent, but now it had ceased manufacturing product as per this patent, and instead began manufacturing different products that infringe the suit patent. That means CTR says though Sergi had a product patent, 089 patent, but it is not manufacturing products as per that patent, and it manufactures the different kinds of products as per the CTR's patent. That means the patent on which we have a discussion right now. Fine. Now, CTR also argued that its patent claims were non-obvious in as much as the arrangement of the three components was inventive and produced a new and improved result. That means we can say that opposing the claims of Sergi, CTR argues that its patent claims were non-obvious. Okay, non-obviousness accounts for the patentability, right? So CTR argues that its patent claims were non-obvious in as much as the arrangement of the three known components was inventive and produced a new and improved result. That means all these things are, we can say, in favor of the patentability criteria. Got it? Okay, let us proceed. Now we will analyze some legal observations. Okay. The single judge of the Bombay High Court, vide order dated 23rd October 2015, found a prima facie case of infringement and also held that all the prerequisites for the grant of an interim injunction in favor of CTR existed. Okay, that means as per the single judge of the Bombay High Court, in the year 2015, as per him, he found a prima facie case of infringement. Okay, and we can say the grant of an interim injunction was done, and this is in favor of CTR. So we can say uh, favors were done for CTR, and it existed and continued. Okay. Now, the court granted an interim injunction in favor of CTR, thus preventing Sergi from selling its Sergi 3000 product as well as any other product that may infringe the suit patent pending the final disposal of the suit, effective from 23rd November 2015. Fine. The court also said, or the court also held, that CTR will be entitled to cost in accordance with the Bombay High Court original site rules. Okay, so we can say the court was in favor of CTR. Okay, so as per the rule, what should be done? It ordered. The court ordered as per the rules. Okay, and all the favors were, or we can say the judgments were in favor of CTR. Okay, let us see what happens next. On an appeal by Sergi. Now the Sergi will not also leave. Okay, Sergi will also not leave. So what he did, or it did, on an appeal by Sergi against the above order of the single judge, the division bench of the Bombay High Court, while staying the order of the single judge, listed the matter for adjudication on merits. However, the judgment of the single judge of the Bombay High Court dealt with certain general principles with respect to patents, in respect of inventions with multiple integers and their infringement, which deserves due deference. Fine. So, Sergi also appealed against the above order of the single judge. Okay. So, the division bench of the Bombay High Court, while staying the order of the single judge, listed the matter for adjudication on merits. However, the judgment of the single judge of the Bombay High Court dealt with certain general principles with respect to the patents, in respect of inventions with multiple integers and their infringement, which deserves due deference. So let us see what happens next. Okay. So let us analyze some more legal observations. Okay. The court pointed out that CTR's patent would not be prima facie invalid merely because the components employed by its system were known in prior art. Okay. The court said, uh, as per the allegations from Sergi, that the components employed in the device were known in prior art. To that complaint, actually, the court pointed out that CTR's patent would not be prima facie invalid just because the components employed by its system were known in prior art. Fine. The court held that in order for Sergi to succeed, it had to show that CTR's combination of the three components was obviously non-inventive. Okay, was, or we can say components was uh, obvious and obvious or non-inventive or self-evident and plain. Or we can say, actually friends, we can also say it like this. The court held that in order for Sergi to succeed, it had to show that the CTR's combination of the three components was obviously non-inventive or self-evident and plain. Fine. The next point. The court held that while the integers or components may be known, but they may be arranged or rearranged in some previously unknown and non-obvious manner to deliver a new or improved result. That means, though the components were known, their arrangement or rearrangement may be unknown, which delivers a improved result. Okay, so the court held that each of the integers must be essential, and that if any one integer can be taken out without affecting the final result, it is not essential. Fine. Thus, the court held that it is not enough to merely state in the opposition that each of the integer was previously known. The opponents must show that the rearrangement of the integers is one that suggests itself for the defense to succeed. That means the court says if the opposite party opposes so much, then it has to show some proofs, some valid proofs. This is the gist. Okay, let us proceed. So friends, the legal observations and the decisions taken by the court continues. Just take a look. The fact that the plaintiff holds a valid patent would not automatically entail the grant of an injunction. Just as a defendant's claim that the validity of the patent would be challenged would not automatically entail the denial of an injunction. Just try to read the statement and understand it, friends. That means here it wants to say nothing happens automatically. For example, neither the plaintiff holds, we cannot say that, just read it again. The plaintiff holds a valid patent would not automatically entail the grant of an injunction, right? That means the grant of an injunction is not automatic as the plaintiff holds a valid patent. Similarly, we cannot say that automatically the denial of an injunction happens when the defendant claims for the validity of the patent. Okay, or the defendant challenges for the validity of the patent. So neither of them happens automatically. Fine. In both cases, the party must adduce evidence that demonstrates the prima facie validity or vulnerability of the patent as the case may be. That means either the validity or the vulnerability are decided based on the evidences only. Fine. Now, the court also held that in cases such as the instant case, the pith and marrow of the patented invention had to be examined. In the present situation, the court found this to be the manner in which the components of CTR system interacted with each other. Okay. Now the court held that the addition of Sergi of any superfluous element would not defeat the charge of infringement. Okay. So it did not address the question of whether Sergi could simultaneously sustain pre-grant opposition, post-grant opposition, revocation proceedings, and a counter-claim challenging patent validity. That means so many objections, so many allegations Sergi had complained about, we can say. So many, or it has so many complaints against the particular party. So the court held that the addition by Sergi of any superfluous element would not defeat the charge of infringement. That means we can say in a way the court is in favor of CTR. Let us proceed. What happens next? Continuing from the previous slide, let us proceed. Having found an overwhelming prima facie case in CTR's favor, the court also held that the balance of convenience and other determinants for interim relief also lay with the plaintiff, thus justifying the grant of an interim injunction. Got it? Now, in the light of these findings, the single judge ordered Sergi not to infringe the suit patent by making, using, offering for sale or selling either the Sergi 3000 product or any other product that is identical or substantially similar to the patented system pending the final disposal of the suit. Got it? So totally in favor of or in favor of CTR. The decision was in favor of CTR. Okay. Now the court also restrained Sergi from circulating any literature, technical brochures, pamphlets, flyers, drawings, specifications or any other material that displays the patented system. That means though Sergi had so many objections, so many allegations about opposing CTR, but the court has very, we can say, intelligibly, or we can say the court had given all the decisions in a very logical way and as per the rules. Okay, so though so many complaints were there against CTR, we can say that justice has been done for CTR. Fine. Okay, let us proceed. Though the decisions were done by the court, Sergi was not happy. Okay, then what he did? He or it appealed. So the appeal before the division bench of the Bombay High Court, that we will discuss now. Although the single judge's order was issued on 23rd October 2015, its operation was stayed until 23rd November 2015 at the request of Sergi's counsel. Fine. However, in the interim period, Sergi preferred an appeal against the order of the single judge before the division bench of the Bombay High Court on the following grounds. So what are the grounds? Ground number 1 is the suit filed by CTR is not maintainable. Okay. Ground number 2, there is no infringement of the patent. Ground number 3, the appellant has raised credible challenge to the subject patent. Okay. On these 3 grounds, it appealed before the division bench of the Bombay High Court. Okay. Now, Sergi also submitted that CTR is guilty of suppression of material facts regarding the fact that Sergi had initiated post-grant opposition proceeding under section 25 subsection 2 of the Act, and the proceedings were still pending. It told that as the proceedings are still pending, and so CTR is guilty of suppressing some material facts. Fine. Sergi asserted that in view of the judgment of the Supreme Court in the case of Alois Oben versus Yogesh Mehra, this is a famous case, okay, the suit filed by CTR was not maintainable. That means it had given some citations as well. Okay, who? Sergi. Sergi also averred that this objection was not dealt with by the single judge in an appropriate manner. So many complaints against the single judge as well from Sergi. Okay, next see what happens. Okay. In light of the above, the division bench of the Bombay High Court in its order dated 1st December 2015 observed that the post-grant opposition proceeding against the suit patent initiated by Sergi before the controller of patents was pending, and also observed that Sergi had raised substantial issues on merits and in law which deserve consideration. Fine. So we can say the bench stayed the interim order passed by the single judge and also held that Sergi is entitled to continue to manufacture and deal in transformers and shall maintain account of the sale transaction of its transformers. So see friends, now something new happened. The division bench of the Bombay High Court in its order dated 1st December 2015 observed that the post-grant opposition proceeding against the suit patent initiated by Sergi before the controller of patents was pending. Okay, it was true. Okay, so it observed that Sergi had raised substantial issues on merits and in law which deserves considerations. Okay, that means the division bench observed that all the objections somehow can be considered. Okay, now in light of the above, the bench stayed the interim order passed by the single judge. Okay, that means whatever interim order was passed by the single judge, it was stayed. And also held, that means the division bench also held that Sergi is entitled to continue to manufacture and deal in transformers and shall maintain account of the sale transaction of its transformers. Now the favorism, or we can say the court was in favor of Sergi. Okay. The bench also directed the controller of patents to expeditiously dispose. Okay. The bench also directed the controller of patents to expeditiously dispose the post-grant opposition filed by Sergi against CTR with respect to the suit patent. Sergi was directed to submit the account in respect of said cell transaction as and when directed in a sealed cover. Okay, so Sergi was directed, that means we can say here till now, or the court directed Sergi to submit the account in respect of said cell transaction, whatever has been done, as and when directed in a sealed cover, which is not opened. Okay. So this way, we can say the decision of the single judge uh, Bombay High Court and the division bench of the Bombay High Court, the decisions were made, and we can say at each situation the court tried to justify. Okay, whether it is the complaint, whether it is the we can say plaintiff part or the respondent part, or we can say whether it is the plaintiff or the defendant, whatever is justice, it should be given, and they tried their best to give it. Fine. So this way, friends, till now we can say that you can go through each and every slide of this case study, and yeah, please, if you are getting stuck somewhere, so please write to me in my comment box. Okay. Enjoy learning and try to understand the case studies very well. Okay, friends? Yeah, happy learning. So, friends, enrich your brain cell with proper food and proper knowledge. So, thank you all, my dear friends, for listening to me and watching my video. Please like, share, and subscribe my channel. Please keep questioning. Please keep learning and keep enjoying. Thank you so much. God bless you. Jai Hind.